Section 16B of the Securities Exchange Act of 1934 reflects Congress's desire to curb insider trading. Anyone with sizable holdings in a corporation's stock is presumed to have insider information and must hand over profits made on short swing transactions of the stock. In Foremost-McKesson Incorporated versus Provident Securities Company, a short swing transaction was made, but the company didn't have sizable holdings of the stock beforehand. Should the insider trading provision still apply? Provident Securities planned to liquidate its assets, and Foremost-McKesson emerged as a purchaser. Provident wanted cash, but Foremost wanted to pay with its own securities. They worked out a compromise. Foremost would purchase Provident's assets using a mix of cash and debentures, debt instruments that were immediately convertible to Foremost stock. Prior to closing, Provident didn't own a substantial share of Foremost stock, but after delivery of the debentures, Provident owned more than 10% of Foremost's common stock. 4 days later, Provident sold the debentures, distributed the proceeds from the sale to its stockholders, and dissolved. Provident sued Foremost, seeking a declaratory judgment that it wasn't subject to Section 16B of the Securities Exchange Act. The provision is designed to prevent unfair use of insider information by corporate directors, officers, and beneficial owners holding more than 10% of a corporation's stock. If a director, officer, or beneficial owner realizes profits on short swing securities transactions, the corporation may recapture the profits. Rather than require individualized proof, the provision creates a presumption that if a person in these classes profited from a short swing transaction, that person misused insider information. The provision covers both purchase and sale sequences and sale and repurchase sequences occurring within a 6-month time frame. There's also an exemption. A beneficial owner isn't liable unless he exceeded 10% ownership, quote, at the time of the purchase and the sale, unquote, of the stock. The district court granted summary judgment to Provident. The Ninth Circuit affirmed, reasoning that liability doesn't attach unless the investor holds 10% of the corporation's stock before beginning a purchase and sale sequence. The Supreme Court granted cert.